Hi everyone, welcome back to Texas Government. This will be the second part of the Texas Judiciary system. So let's get started. Here you will see that there is an annual report that is taken on the Texas courts. The one that I have listed on this link dates back to the fiscal year 2018. I'm sure if you go on to the link, you will be able to find one for 2019. If not, it should be coming out here shortly. Be aware, because we have so many courts in the state of Texas, it does take them a little bit of time to try and gather all of this information. But it is statistical information, so you can see the number of cases, the number of courts, and it is broken down by all sorts of information, so that if you have an interest in what is going on in the courts of the state of Texas, you can find that information on these annual reports. Now, the first court that we will start with today is the county courts at law. Remember, at the very bottom of our chart for the Texas courts, you will find the city municipal courts and the justice of the peace courts. Next are the county courts at law. As with the case of the other two courts, the county courts at law are created by the Texas legislature under constitutional authority. Yet again, this means that the courts are named in the Constitution, and as our population grows, it is up to the Texas legislature to decide when another court is needed and therefore created. In the county courts of law, their original jurisdiction will be over Class A and Class B misdemeanors. Now, their appellate jurisdiction is over the municipal and JP courts, meaning if you have a case in the municipal courts or in the JP court and you would like to appeal, then you would be appealing to the county courts at law. As of the fiscal year 2018, there were 245 county courts at law in the state of Texas. Their caseload consisted of just over 94,000 cases in that 1 year. The judges for the county courts at law are elected officials, and they are elected to 4-year terms. Next, we will go to the county district courts. Now, the county district courts, as with the cases with the other courts in the state of Texas, is created under constitutional authority by the Texas legislature. Now, their original jurisdiction is a bit bigger. The county district courts will have jurisdiction over all felony criminal cases. They have jurisdiction over divorce cases, cases involving title to land. If we have an election and there is a contested election result, that matter will be before the county district court. Also, the county district courts are responsible for civil lawsuits in which the amount of controversy or damage is over $200 or more. The county district court is also responsible for matters that do not fall under another trial court's jurisdiction. Now, in densely populated counties, this means in counties with very large numbers of people, such as Harris County or Dallas and Tarrant counties, you will find that the district courts are very specialized. This means that the district courts will only handle very specific matters. They will either handle all civil matters or all criminal matters or all juvenile matters or all family law matters. This is because of the number of people that are in that county, and therefore you will have so much more in the way of volume to deal with when cases are filed. In order to combat a backlog of cases, the courts are divided by the specific matters so that each court will know that they will only ever have to handle cases that are civil or that are criminal or that deal with family law matters. Now, as of 2018, there were approximately 469 district court cases. Note, the district court is considered to be the chief trial court of the state. What this means is that most cases in counties will be filed at the district court level. This is at the state district court level. Just by the simple regard that the cases will deal with Texas law, this means that district courts will handle more cases than the U.S. district courts. The state courts will handle more cases than the federal courts. In 2018, district courts in Texas took in more than 194,000 new cases. Be aware, though, that in the state of Texas, most juvenile cases are tried in district courts. As I said in the previous slide, in especially high density areas and high density counties, there will be courts that will be specific to only juvenile matters. Now here you will see a map of the Court of Appeals system in the state of Texas. If you will look, you will see that there are 14 district appellate courts in Texas. In the Harris County area and its surrounding areas, you will see that we are serviced by 2 appellate courts due to our dense population. Those courts are the 1st and 14th Court of Appeals, and you will see them down at the bottom right hand corner of the Texas map in a light yellow color. Now, as I stated, the courts of appeals in the state of Texas consist of 14 courts for the various districts. The Court of Appeals, these intermediary courts, these 14 courts will hear appeals for both civil and criminal cases. Now, the justices for these courts are elected to 6-year terms. The candidates that would like to run for this office must be at least 35 years of age and have a minimum of 10 years experience as a lawyer or a judge. Either or, you have to have one of those requirements in order to run for the office of Justice of the Court of Appeals. Now, the highest courts. What we have in the state of Texas is a bifurcated court system, which came about through a constitutional amendment in 1891. What this means is that we have a bifurcated a two-system court, the first being the Court of Criminal Appeals, this is the highest state appellate court in criminal matters. The judges elected for 6-year overlapping, meaning they are staggered terms. Not all justices will be elected at the exact same time. Of course, if you would like to run for this office, you must be at least 35 years old, and the candidate would have to be a lawyer or a judge from a lower court with at least 10 years experience. Now, the Court of Criminal Appeals. They have exclusive jurisdiction over automatic appeals in the death penalty cases. This means that if someone is given the death penalty at the district court level for having committed a crime, their case will automatically be appealed to the State Court of Criminal Appeals. Now, capital punishment in the United States was restored in 1976, and since then, Texas has executed far more individuals than any other state. When an execution is getting ready to happen, you will see a lot of media attention put on the case, on the person that is to be executed, and you will see protests will start happening up in Huntsville where the execution chamber is located. Now, the Texas Supreme Court is the final court of appeals in civil and juvenile cases. Their original jurisdiction consists over issuance of writs, meaning orders, and also conducting proceedings when a justice is trying to be removed. This is usually when a justice has done some sort of illegal act, or a justice is being removed due to their behavior, or some sort of issue has come about medically that they have to be removed. In order to be a justice for the Texas Supreme Court, an individual has to be, of course, at least 35 years of age, a citizen of the United States, and resident of the state of Texas, and they also have to have been a lawyer or a judge of a court, of a different court, for at least 10 years. When it says a court of record, this means a trial court. This would be a justice. You would have to have been a justice of a court at the county or district court level. Now, a true bill is an indictment that has already been approved by the grand jury. Now, how would you serve on a grand jury? The grand jury is a lottery. If you have a state-issued driver's license or a state-issued ID, you are subject to get called for either jury duty or to serve on a grand jury. So do not be surprised if you end up getting a summons to come down and serve as a member of the grand jury. Now, a petit jury. A petit jury is just a trial jury. These are the 6 or 12 individual persons that sit on juries and hear the entire case that is before them. In the county courts, there are 6-person juries. In the district courts, you will have 12-person juries. Juries will be held over for civil or criminal trials. As I said, you may be picked to be on a jury panel, and you are selected from the state's driver license directory. Now, the County Commissioner's Court. The County Commissioner's Court is created by the Texas Constitution. Each county has a county court, so there are 254 county commissioner courts. However, these courts have very limited jurisdictions. Most do not perform any kind of criminal or civil court activities. Their jobs are administrative. The county judge serves as the head of county government. The county judge is the one that will run the county commissioner's court. If you have seen the news lately, you will have seen that in Harris County, Lena Hidalgo is the current county judge. It is her job to serve as the head of county government. I have given you a link to the Harris County Commissioner's Court. Please feel free to click through and see what district your home falls into and who your county commissioner is. Now we will talk about probate courts. Now, probate courts also are created under the Texas legislature under constitutional authority. As of 2018, there were 18 probate courts. Now, the probate courts have original jurisdiction in the state's largest metropolitan areas, meaning in the state's largest cities. Statutory probate courts have exclusive jurisdiction over matters such as guardianship cases, mental health commitments, the processing of wills and estates. Um, this is what is meant by probate. We are dealing with very specific family style matters, such as mental health, guardianship of young children or guardianship of older adults, uh, being able to serve as a conservator for another person's estate, or to help another person who is unable to do it themselves to handle their affairs and matters. These types of cases would be handled by a probate court. Now be aware that for probate courts, the Texas Constitution grants the legislature the authority to determine if Texas courts have jurisdiction over probate matters. Now, depending on how the legislature assigns jurisdiction to courts in any particular county, probate matters may be heard by a county court at law, a statutory probate court, or a district court. Because there are some counties in the state of Texas that are very small, there may not be the ability to have a very specific probate court, in which case one of the county or district courts would be assigned probate matters. The caseload for these courts as of 2015 were an additional 105,000 new probate and guardianship cases that were being filed. Now, in Texas, judges are selected by election. These elections are partisan, meaning that you will be able to tell what party the judge or the person running for that judicial bench affiliates with. Don't forget, a lot of justices are appointed because they are being appointed by the governor to fill vacated offices. So when a new justice is appointed, they still have to receive the advice and consent of the Texas Senate. They will finish out the term of the then current bench, and when the next election comes, they will have to run for their own seat. Now, some states use the merit plan where justices are first and foremost appointed by the governor. They do not have to seek election until they have served out their initial term. So they are firstly appointed by the governor and then retained by election. In the state of Texas, justices are elected from the very get-go unless they are finishing out somebody else's term. Now, if you have any questions, please feel free to email me. Otherwise, this is the end of the Texas Judiciary system. I will talk to you guys next time. Y'all have a good one. Bye.